This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address for Ask a Lawyer. It's June 25th, 2021. We are almost halfway done with the year. A special opening message to my mother for her 85th birthday. The best present I can give her right now, actually the worst. Happy birthday to you. Happy birthday to you. You're getting a birthday on the radio. Happy birthday to you. All right, now that everybody agrees that I have a horrible singing voice, we'll move forward.
Yeah, you're okay unless the people disagreeing are judges.
Well, yeah, they probably are. They're all judges. Today, we're living in a sort of a post-pandemic COVID world. Businesses are starting up again. Businesses are active again. Some are just beginning to open. And we really should look at the implications of going back to business in a post-COVID world because it has serious implications for employers and employees. In particular, if you're concerned about going back to work, if you have questions about whether or not your employer can require you to be vaccinated, if you have questions about whether your employer can ask for proof of vaccination. I've heard a lot of people talk about, well, isn't that a violation of HIPAA? And for those on Facebook Live, you can also get the audio and video if you want on WPSL.com. So if you want to watch the video on Facebook Live, you can also listen to the audio on WPSL.com. We've seen, for example, non-compete clauses, which we've talked about a lot, go through several transitions as much of the workforce has shifted to a remote working environment. A lot of people are staying remote or staying partially remote. And so, how does this impact a non-compete agreement? Well, employers are actually still struggling with how to deal with remote workers and the language of non-competes, which may have existed pre-pandemic and haven't been changed. And those clauses, when they're being litigated, are getting much more scrutiny. More specifically, those clauses in many respects have garnered the attention of state governments who are legislating aspects of these non-competes, and the federal government has begun to look into it as well, at least in terms of the Equal Employment Opportunity Commission. Now, there is no law yet in Florida or any other state so far from my research. However, there are some remote law precedent from the pre-pandemic world, and that we can look at for some guidance. In 2016, a California court faced this issue, and the case went to appeal, and it was now sent back to the trial court, and the trial court still hasn't ruled. So we're looking at, well, what can an employer enforce in terms of a non-compete? Let's say you used to go to work, this is the California court, in downtown LA, and your non-compete said you can't go to work for another competitor within 20 miles of your work location for 2 years. And now you're working remotely, back where my sister used to live, Tarzana or Woodland Hills, is it? I don't know.
Sure.
And is it 20 miles from there? Or is it 20 miles from LA? It's really important.
It's interesting you say that. I know someone who, and this happened to him, that, what the employer tried to do was not the distance from their business, but the LA city limits, which is massive.
Well, right. And when it comes, Greg is saying he knows an employer who tried to, interpret it from the LA city limits, which of course is a massive location, sort of like, all of Manhattan Island. It really depends so much on the specific language of a non-compete. When I get calls to my office about non-competes, I ask them either to read me the language of the duration and scope or to send it to me, because it is really hard to give any sort of an opinion without really knowing what the language is. Some non-competes have language that is very precise, and some of them you can drive a Mack truck through in terms of what was really intended, particularly when you start out working in an office and then you go to remote working. Well, was there ever any intent in that circumstance? And how can these things best be interpreted? Because if you'll remember from some past shows, non-competes are a very unusual type of contract, or a very unusual type of a clause within a contract. Courts can rewrite them. Courts don't rewrite normal contracts. It's just not a canon of contract law. But in non-competes, from way back yonder in the colonial days, and even British common law, the courts had the power to rewrite non-competes to make them reasonable. So if you have a non-compete that says you can't compete for 2 years anywhere in the world, the planet Earth, it's not going to be enforced. But instead of just saying, well, there is no non-compete because that's unreasonable, the court will take evidence and will rewrite it. They call it, blue penciling. So we have to really look, particularly when it comes to remote workers now, as to the litigation that is probably begun in many states, is going to blossom. I've seen lots of continuing legal education classes on this very topic, and we can stay tuned for an answer. Another issue that comes up in the post-COVID world is, well, to what extent can you still take time off to care for yourself or your family if there's an illness, if they get COVID, if you're concerned that you or they may have COVID, if you're self-quarantining because of it? You may remember that, about this time in 2020, Congress passed a couple of statutes. One was the Families First Coronavirus Response Act, and it required certain employers to provide employees with paid sick leave or expanded family and medical leave for specific reasons relating to COVID-19. Now, under the FMLA, we know, if you've listened to other shows, in general, if you work for a year full-time or 1,250 hours, and if your employer, has more than a certain number of employees, then you're entitled to family medical leave. You're up to 12 weeks a year, unpaid. Well, the Families First Coronavirus Response Act changed that. The first 2 weeks were paid. And it also required paid sick leave, separate from FMLA. So I've seen in literature, and I've gotten a couple calls in the office about this issue, it doesn't apply anymore. The provisions of the Family First Coronavirus Response Act applied until December 31st, 2020, and they were not renewed. So this concept of, can I get paid sick leave because of a COVID-19 related issue? No, not unless that's the policy of your employer. Can I take my 12 weeks and get 2 of those paid? No, that is no longer the law. It was the law for a short period of time, let's say 8-9 months, until the end of 2020. And as Congress is generally in gridlock, it did not do anything to extend that relief. So what you're entitled to is solely based upon the policy of your employer or what you may be entitled to under the FMLA. If you've worked long enough hours, the employer has enough employees. Now, there may be other rights that you may have that derive from OSHA, the Occupational Safety and Health Administration, or from the ADA, the Americans with Disabilities Act. We've talked about those a lot in other shows. So what then about the ability of an employer to require COVID testing and or vaccination as a condition to return to work or remain on the job? Now that is absolutely exploding. I've had a call within the last 2 weeks from a Fortune 100, an employee of a Fortune 100 company that wanted to know whether he could be forced to go back to work and be vaccinated, whether he could be forced to tell his employer the results of a COVID test, whether he could be forced to take a COVID test, whether he has a right to continue to work remotely. And within that overall rubric, we've had a few calls, and I know that other attorneys are getting lots of calls in many states. So let's start looking at that. And let me remind you, you can always call in at 772-340-1590 on this or another topic. And we can try to make this a more interactive process as opposed to one that will require lozenges afterwards. All right. There is guidance that was given by the Equal Employment Opportunity Commission, the EEOC, relatively recently. Its most recent update is May 28th of 2021. So that's within the last 4 weeks. And this is the guidance from the EEOC. Employers can ask employees whether they are vaccinated. They can ask you if you are vaccinated. Such a question is not considered a disability-related inquiry. As the EEOC has said, there are many reasons why an individual may or may not become vaccinated, and thus an individual's vaccination status does not reveal the existence of a disability. Now, what is that in plain English? Well, maybe you don't want to get vaccinated because you have an underlying health condition and the vaccine may aggravate it. If that were the case, and that was the only reason that somebody might choose not to get a vaccine, then that would reveal a medical situation merely by asking whether you were vaccinated. But as we all know, there are a myriad of reasons why people are choosing not to become vaccinated. Some personal, some religious, some political, some hogwash, some very justifiable given their individual circumstances. So what the EEOC is saying is the employer can ask, are you or are you not vaccinated? Because your answer does not necessarily indicate any health-related issue. So when inquiring, though, about your vaccination status, an employer should refrain from asking other questions that may get from you medical information, such as questions, why didn't you get a vaccine? That's not permitted, because your answer to that question might disclose health information which you're entitled to keep from your employer. That would violate the ADA, the Americans with Disabilities Act.
Okay, what if somebody says, a long time ago, I was allergic to penicillin and I'm afraid of those?
Well, first of all, that question shouldn't be asked, is what I'm saying, and is what the EEOC is saying. Asking, are you vaccinated? You say no. That's the end of it. Now, if you volunteer, that's certainly up to you. We all know that in this country, people can give up their rights. You can give up rights to freedom of speech, press, religion, all that stuff. But the employer cannot require it. And the EEOC has basically determined, and I agree, that the medical aspect of your vaccination status, it's confidential medical information. And that's for purposes of the Americans with Disabilities Act. And so that upon receiving information regarding an employee's vaccination status, an employer should treat the information as confidential and keep it separate from the employee's other personnel information, personnel file. And that's important. Let's say you choose to disclose something to your employer, or let's say somehow it comes out in another respect, and we'll get to one way that might happen in a moment. That information cannot reside in your good old personnel file. That information, like other health information, has to reside in a separate file. Otherwise, there could be a violation of the ADA and of HIPAA, although then I go back to my old rant. There is no private cause of action under HIPAA, although creative lawyers across the country are coming up with things like invasion of privacy, etc. Okay. Now, employers can require you to become vaccinated. I'll say that again. Your employer can say you're not returning to work unless you get vaccinated. Your employer can say you're not staying on the job site unless you're vaccinated. And then ask for the proof. Ask, are you vaccinated? Now, we're going to get to an exception here, because if the employer can ask for the proof, ask whether you're vaccinated, and doesn't have to rely upon you simply saying yes and being truthful, can it get proof of the vaccination status? Can it ask for it? And can it receive actual proof? There's a little wrinkle here. In general, the EEOC is saying that an employer can institute a mandatory vaccination policy for employees either entering the office or returning to the office, subject to obligations that exist under anti-discrimination laws, such as the ADA, Title VII, and state or local statutes. When they get the vaccination information, even if it doesn't come with a medical reason, when they get the vaccination information, yes or no, they have to keep that information separate. And they can't force you to get vaccinated if you have a disability that would indicate you have a legitimate reason not to get vaccinated, or for example, a sincerely held religious belief. They can't require. They can't require something that would violate Title VII of the Civil Rights Act, the discrimination laws, or the Americans with Disabilities Act. Now, the EEOC guidance notes, acknowledges, and admits it has limited jurisdiction, which means that there can be state or local laws that limit an employer's ability to implement a mandatory vaccine requirement or to require evidence of your vaccination status. Guess what? Here in Florida, we have such a limitation. You may all recall that Governor DeSantis, about a month and a half ago, issued an executive order that said nobody can require proof of vaccination, can't require a vaccination card. This is in the news a lot because of the cruise industry. You know, cruise lines are basically saying, you know, since the CDC, Center for Disease Control, has said you have to have at least 95% of adult passengers vaccinated and 99% of crew in order to sail out of American ports, and we're restarting the cruise industry. A lot of these major cruise lines, Royal Caribbean, Norwegian, Celebrity, Princess, Carnival, they are asking for those good old vaccination cards or the equivalent. For example, I lost my vaccination card. I could get another one, but I do have a printout from the CDC website which shows all that same information. So that's the equivalent. But in Florida, Governor DeSantis has said you cannot ask for that. And that has led to litigation in federal court going on right now, which is going to determine whether or not these cruises that were scheduled to start in early July next week in Florida, in order to beat Texas as the first American port to restart cruising, whether or not that can happen. And in fact, I don't recall which cruise line, it may be multiple ones, but I know at least one major cruise line has said, nope, we're not starting on July 3rd. All cruises are canceled through the end of July. Why? Because they don't know whether or not they can ask for proof as to whether you're vaccinated. And that means they can't sail within U.S. waters. So until this is resolved, you know, Governor DeSantis has basically decided, I'm going to play chicken on the Maritime Highway and see who blinks. The Center for Disease Control, which the cruise industry has to listen to, or the cruise industry. Now, they can't blink because if they do, they could be massively fined by the federal government. So will the federal government blink and back down on this requirement? Or is Florida going to blink? Or is a court going to simply determine the answer? I suspect it's going to be a court that is going to enter at least a temporary injunction and will probably, I'm going to guess, permit the cruising and asking for the vaccination status and evidence of the vaccination status, subject to resolving the entire litigation on its merits, which, you know, could take a year or two. That's just my guess.
Throwing a monkey wrench into this, what if a federal courthouse had a rule that you had to show a vaccination card to work there? Now, would that be under federal jurisdiction or the state jurisdiction that it's in?
Well, you know, that is a very good question. Greg says, well, what if, you know, a federal courthouse has a rule that you have to show evidence of vaccination? What would apply? The federal law, because it's a federal courthouse, federal building, or state law? Well, the simple answer is I don't know. Until that gets litigated, I don't know. But since a federal building is not federal property, like being in the UN or being in an embassy, you know, if you go into the Soviet embassy in Washington, D.C., you are in, well, the Russian embassy, you are in Russia. For legal purposes, we create a fiction. The fiction is when you get through those gates, you are in Russian territory. You're in, Canadian territory. You're in Australian territory. Once you pass those gates, you are on the land of that country. It's a legal fiction. And that's why we can't go past those gates. That's why in most countries in the world, they can't go past those gates because it's our land. But since a federal building is not the equivalent of an embassy or being at the UN, I suspect it must obey state law, the state in which it sits. And in Florida here, since you're not allowed to ask for a vaccination card, I would submit that the federal court may not permit their employees or may not require their employees to show evidence of vaccination because it's against Florida law. What say then, you know, I love this stuff because first year of law school, the thing they teach you, they keep questioning you, and they take you further out on the analogy until, as they say, you're so far out on the branch, it breaks. And the logic you're using no longer works. It's ridiculous. So let's do that. Let's change the question from the vaccination card to wearing masks. Now, Governor DeSantis has said that no state or local municipality can require masks anymore. However, private employers can. So you can see a sign that says, you know, you must wear a mask. In fact, I'm seeing newer signs, actually. I'm seeing pre-printed, very professional looking signs at the entrances of restaurants and things like that that say you must wear a mask unless you're vaccinated, unless you have a legitimate reason not to be vaccinated. They're not asking for cards or proof, you're on your honor system, but it no longer says, you know, all customers must wear masks. It's a more nuanced sign, which most people will walk right by and never read, because since it's not in big letters, you must wear a mask, and it gives certain situations, most people just blow right by it. But okay, so let's say the federal court wants to have a rule, in fact, I think it does, that you must wear masks while in the courthouse. Why is that enforceable if the vaccination card isn't enforceable? And here's a great lawyer answer. I don't know. My understanding is that you're required to wear a mask in a federal courthouse. I don't know why that should be any different than being required to show a vaccination card. What I do know is you have two competing issues being handled differently, and to me it doesn't make sense. You can require the mask in the courthouse, but I don't believe you can require proof of the card. I believe that violates state law. Why it is that way and for how long it might remain that way, I don't know. You know, I'm going to submit that a good lawyer very often will simply say to you, I don't know. Right? Because I had this discussion just yesterday. 90% of law is gray. 10% is black and white. That's why they call something black letter law. It's been so long established that, you know, it's not subject to a dispute. But the rest of law is truly gray. It depends upon the facts. It depends upon the wording of a document. It depends upon how you interpret a comma or a semicolon in a statute. That's why lawyers exist. For good or for bad.
Okay, let's talk about a federal courthouse. Let's say you've got,
all right.
Let's say you have a case in the federal courthouse, and you are a very politically astute, I guess, if you will, individual who really objects to all this. And the guards stop you at the front gate of the courthouse and say, you have to wear a mask. And you say, I don't believe in that, but I have a case here. Then what do you do?
Greg is taking me out on that branch. Greg is, for those on Facebook, Greg is posited. What if you have a case, an actual case in the federal courthouse? There's a requirement that you wear a mask. Politically, you don't believe in wearing masks. And when the good old deputies, actually the marshals, stop you and say, put a mask on, and you say, well, I don't believe in it, what happens? I have a case here, I have to enter. Well, I don't think you're going to be entering if the marshals don't want you to enter. And you're going to be left to maybe call the judge's chambers and either have the judge order an exception and order the marshals to allow you to enter, or tell you, well, if you're not here, that's your problem, but we're proceeding. And then you can decide whether you want to make an exception, wear a mask or not. I can tell you, I know the answer to that question is going to be the marshals are not going to let you in if that's the rule. Now, can a judge overrule a marshal? Absolutely. As we all know, federal judges are God in their courtroom. Okay, you cannot do anything to them except have them reversed on appeal or have them impeached. Other than that, what they say goes. So if they tell the marshal or the head of the marshal's unit in the courthouse, admit Bill Smith, he has a case in my courtroom, they're going to admit Bill Smith. Now, could the judge theoretically, let's go out on that branch, could the judge theoretically get in trouble for that decision? Yeah, in a few ways. The chief judge of the circuit, Southern District of Florida, could discipline the judge, or somebody could sue the judge, and we have another court case, or take the judge up on appeal, but ask for an emergency appeal or something, I don't know, to the 11th Circuit. But other than those few things, the only other recourse is impeachment. And we know how that process works out. It is long, tedious, political, and it's not going to get you into the courthouse that day for sure.
So then what happens if to the marshals if the judge tries to overrule them and they still don't follow his orders, saying we'll just go to the chief magistrate or something?
Well, I mean, it's sort of like following unlawful orders. You don't have an excuse to just say I followed orders. If the marshal, the U.S. Marshal believes that what a judge is asking him or her to do is unlawful or unconstitutional, then the marshal has a duty not to do it and to take some other course of action. Now, the marshal may be risking the job. If you disobey an order, in combat, you better be right. Because if you're wrong, you're getting court-martialed. You may be going to the brig, maybe going for a long time, maybe getting drummed out of the service with a bad conduct, discharge. The thing is, when we risk disobeying something significant, it's good that people will do that. It really is. You can't just say I was following orders. That was established, if nowhere else, in the Nuremberg trials of the Holocaust. You can't just say I was following orders. On the other hand, you better be right if you choose not to. Because if you're wrong, you're going to get punished. And so a marshal that might risk his or her job because they believe something is unlawful, well, I guess if they're right, I admire them. If they're wrong, but they are acting in good faith, I respect them. If they're just wrong, I guess they're not going to have a job anymore. Now, let's change the venue a little bit. Let's go to the U.S. Capitol on January 6th. 2021. What if the Capitol Police chose to close the Capitol, bar the doors, I'm sure they have covers for the windows, against the instructions of the Speaker of the House, the President of the Senate, the Sergeant at Arms, whoever the lawful authority is that can issue an order, the Capitol remains open. But they saw the assembling mob and they made a decision. I'm not following this order. They don't know all the facts. I see what's going on, and I'm directing my group. I'm in charge that day, let's say of this shift. I'm directing everybody, shut down the Capitol, put the irons on the doors, put the covers on the windows sort of like a hurricane. And now the Capitol has been shut down, the seat of government. Boy, that is a big deal. But what if on January 7th, it's determined that what that Capitol police officer did was save us from what occurred on January 6th? Well, that's a pretty good decision.
Well, and you look at the Capitol Police, they knew 6 weeks in advance that there was going to be some major problems at the Capitol. Why didn't they prepare?
Very good question. Why didn't they prepare with all the information they had? I don't know. Why was the National Guard withheld for so long? I don't know. That is the subject of hearings that I've seen on Capitol Hill. I've heard testimony on it. I've heard some very, very good questions from senators. I've heard some very stupid questions from senators. And again, a lot of this is just political. I'll deviate from topic for a moment, and I love doing that. This week on the U.S. Capitol, that good old Representative Gates, who seems to be making a name and a fool of himself, a Republican, there was a hearing, and he tried to dress down a couple military generals about this, what is it called? Race something theory. And the military's teaching it at places like Annapolis. And how this is a horrible thing to teach, and General Milley wanted to interject before another general, who he was above, was going to answer. And of course, I think it's Representative, not Senator, Representative Gates wouldn't permit the interjection. So the other general answers and dresses him down. And then another representative says, well, I'll give you, General Milley, a few minutes of my time if you want to respond. I think you had something you wanted to say. This is a great clip. Go to YouTube, folks. General Milley proceeded to basically pull Representative Gates' pants down and spank him, and explain that places like Annapolis, they're universities. We teach there. We teach things we don't believe in. He says, I've read Lenin. I've read Marx. I've read Mein Kampf. That doesn't make me a communist, a socialist, or a Nazi. Just because I learn it doesn't mean I believe it. In fact, often we learn things so that we can learn from it, not abide by it. And General Milley explained that in as clear a fashion as one might expect a very high-ranking general can do, and with such authority of voice that there was no disagreeing with him. I thought it was wonderful. I've listened to the clip, and I just thought it was wonderful. And he said, something, even separate from it being a university, if we teach it, to our troops, if we teach it to our enlisted, doesn't mean we're teaching it so that they follow it, that they believe it. Very often, you need to understand where other people are coming from. That is why we teach it in the military, he said. Now, what he didn't say, but I'll say, is if Republicans and Democrats would learn that and remember what it used to be like when they disagreed, but could still negotiate and come to rational agreements and not save everything as a political issue for the next election, and then save it again for the next election and the next election, depending upon who won an election or didn't win an election. If they would act like grown-ups and say, okay, we agree on this, let's do this. We don't agree on this, but our disagreement is not so far away. Let's compromise. And on these issues, we are so far apart. Okay, fine. Save that to another day. If they would behave like that, we'd have so much better laws.
Yep.
Much better.
No doubt. And it's funny you mentioned the general's comment, because that brings me back all the way to my college days. And there was like World War III on our campus at Loyola U when the Jesuit priests invited Angela Davis to be a guest professor to teach communism at Loyola U. Again, the fact that we're there to learn. We're there to learn about everything. And that was it. Well, there are a lot of irate parents that, went up against the university, and the university basically said, she's coming. And she did. And it was interesting.
Greg is right. Greg's talking about when, in his old days, when he was at Loyola, and they invited a guest professor to teach a course on communism, and there was an uproar, and the Jesuit school. Well, the response was simply, yes, she's teaching the course on communism. This is a university. You come here to learn. You come here to understand. You come here to learn how to think on your own. You come here to learn how to separate fact from fiction. You come here to learn when a speaker has a bias, calculate that bias into what they're saying to come to your own conclusions. You learn that just because something is said by the Democrats or the Republicans doesn't make it true or untrue. What makes it true or untrue, or good policy or bad policy, is how you perceive it to be based upon the information you can acquire. Just because, well, we don't want to go too far into that political thing, but I absolutely agree. And back in my days, and I hate to say things like that because it really does make me feel old, but back in my days, it was understood that you're at a university to learn and to learn to distinguish, and that means you study things that you're not supposed to believe, but you're supposed to understand. I mean, I went at Rutgers University. I was in a college across the river that was sort of like the colonies in England. They created this other college across the river in the 60s during the race riots to satisfy minorities. And it became basically the college for minorities and first-generation college students, of which I was, the first-generation college student. And so I chose to go to that particular college within Rutgers, which was definitely at that time second-class citizen. And the political science and the sociology departments on that college campus across the river really taught Marxism, communism, socialism, and some of these professors actually did believe it. Well, I still took those classes as somebody studying political science. They were fascinating. But yes, I went across the river too to Rutgers College, which was very staid and conservative. And I learned the stuff that most of us believe in, capitalism. And I learned to understand why the arguments were that it was better, and sometimes not better, than socialism, and where socialism has sometimes actually an advantage. And wow, if we can understand all that and meld it all together, which is what I think Congress is supposed to do, wouldn't we all be the better for it? Now, great example. these $300 weekly extra checks for unemployment. They were a great idea last year during the height of unemployment. Were they abused? You betcha. Did they encourage some people not to work? Absolutely. But the question is on balance. Did they help or hurt? Not did some people abuse it. Now, if you come to the factual conclusion that on balance they were bad, then you're going to make new policy based upon that conclusion. If you come to the conclusion on balance they were helpful, then you're going to try to make policy based upon that. But, you know, I hear so much condemnation about policy, you know, because of a small percentage of people who abuse it. Like the first round of Paycheck Protection Program loans to small businesses, I got one, but at first I was closed out because they went to these massive employers, these multi-billion-dollar companies who ended up having to give them back because they got humiliated, and I couldn't get my loan. Well, once you get public relations damage and you start to return the money, and then Congress says you have to return the money or you're committing a crime, and all that money starts coming back and it starts funneling out to small businesses. That's when I got my first round of the Paycheck Protection Program money. Great program in my view. Abused like you can't imagine initially. Why? Because the language of the statute wasn't tight enough. You know, you can't always project everything that's going to happen. And that's why statutes get amended. And that's why when we refer, for example, to Title VII of the Civil Rights Act, there are two words we don't usually add. They're in parentheses. Title VII of the Civil Rights Act, as amended. No, we have 5 minutes. Okay. Civil Rights Act's another great story. This was something that was championed by President Kennedy, and after he was assassinated, President Johnson, who really didn't believe in a lot of this stuff, decided, since that was to be President Kennedy's signature legislation, he was going to push it through, whether he didn't personally believe it or not. And he came to believe in a lot of this, but we couldn't get voting rights in the initial statute that was passed, 1964. You could not get a majority of senators to say yes. There were Southern Democratic senators that once said no. So what did they do? Did they say, okay, no Civil Rights Act? Baloney. They did what they were supposed to do. They fought and they fought and they fought, and President Johnson wrangled, people and bullied people and made trades, and they got to agree upon certain titles of the Civil Rights Act, the over one that was introduced. And they passed what they could pass. And did that mean it was broken? Yeah, it was broken. There were things that weren't included, like voting rights. But it got amended and amended until we have what we have now, which should still be amended, particularly in my view, what's going on right now with voting rights. In order to combat what the states are doing, you need the Congress, you need the federal government to amend, the Voting Rights Act and the voting rights bills that have been introduced. So you don't just give up because you can't get everything you want. And I wish that more adults in Congress would learn that lesson, because it seems like it's more, well, you don't agree with me, I'm taking all my marbles and I'm going home. And maybe more of them should go home. Right. We will obviously end up continuing with this COVID and the vaccines and proof and evidence and all the things that employers can and cannot do. Next week, I will tell you that employers that are implementing vaccine policies, are looking at and should be looking at what are considered best practices. They are and should be reminded about the ADA, and that in implementing these policies, they have to be careful not to violate other laws. This is not easy stuff. And that's why employees are calling offices like mine. Employers generally are calling other offices. People are asking questions. Lawsuits are being filed. This is how we get answers. And that is why I say that 90% of the law is gray, and why I say that a good lawyer will often say to the client, I don't know. Now, you can't leave it at I don't know. I don't know should be followed up by I'll research it. I'll see what best answer I can come up with. But very often, I don't know is the best and most honest answer a lawyer, a doctor, anybody can give you. What you want, I think, is something after the I don't know. But what you don't want is somebody spouting a lot of BS because they don't want to admit they don't have the answer to the question. And I think too many people do that, and I'm probably guilty of it sometimes myself. And I hear the little music beats in my ear, and that tells me that my time for lectures today is over. And so I hope you all have a wonderful weekend. I hope you're all starting to get out again. I hope you still get vaccinated. We have a large portion here coming up to the July 4th holiday. And be back next Friday for another edition of Ask a Lawyer. Thanks for listening. Bye-bye.
You're listening to Ask a Lawyer right here on WPSL, Port St. Lucie, the talk of the Treasure Coast, webcaster to the world on Alexa, Google Home, and TuneIn worldwide.